the Tribunal. All rise.
Welcome to all of you of the 2021 session of the Turkey Tribunal. First of all, I will give the floor to Rector Yves Flückiger of the University of Geneva.
Excellencies, dear judges, dear colleagues, I'm very honored to be here with you today for many reasons. First of all, because human rights are so closely related to the city of Geneva. 73 years ago, the Universal Declaration of Human Rights was accepted by the United Nations General Assembly, a declaration that we must recall more than ever at a time when populism seems to be gaining ground with the advent of post-truth. 73 years ago, the recognition of this declaration, I also wish to recall the importance for Geneva of its commitment to international Geneva and human rights. Geneva is heaven for human rights, and our university will always support all actions that can contribute to finally achieve a society that is more respectful of the rights and freedoms of each and every person. As a rector of the University of Geneva, it is one of the axes of my action in the service of Geneva to make our competence exist on the international scene so that we can serve a world that we hope will be better. Let me give you just 4 examples of the involvement of the University of Geneva in the field of human rights. To start with, let me mention the program In Zone. It's a program of the University of Geneva, and it pioneers innovative approaches to higher education in communities affected by conflict and humanitarian crisis, with the ultimate goal of empowering people on the move in stranded transit countries. In Zone gives special attention to refugees and asylum seekers stranded in fragile states, but at the same time foster own inclusive approach, including people on the move more broadly, as well as vulnerable host communities. The objective of In Zone are many ways we encounter the goal of our university. The second example is related to the Geneva Academy for Human Rights, which provides postgraduate education, conducts academic legal research and policy studies, and organizes training courses and expert meetings. It is concentrated on branches of international law that relate to situations of conflicts, protracted violence, and protection of human rights. It was established in 2007 by the Faculty of Law of the University of Geneva and the Graduate Institute for International and Development Studies. It has gained a global reputation for excellent teaching and research, and it attracts exceptional students to its master and training program. The graduates of this program are employed around the world promoting and protecting international humanitarian law and human rights in governments, NGOs, international organizations, and academic institutions. The Geneva Academy does contribute to the dissemination of legal knowledge on this crucial sector. The third example is related to the Geneva Center in Business and Human Rights. Never before has the bar for business success been higher, Companies operate in an increasingly competitive global business environment, and they are also expected to conduct their business in a way that does not cause harm for people or the planet. In a world that is increasingly interconnected and transparent, companies are not only accountable to national laws and regulation, but also to public expectations. By placing human rights at the heart of their business models, companies can reduce systematic risk. They can build more resilient supply chains and stronger organizations. Companies that embrace this challenge are set up for long-term business success. At the same time, they become a force for sustainable development that creates value for business and society. We, as universities, are responsible to train our students to transform our societies in a more friendly space for human rights. Human rights law is that essential material which, with a human rights lawyer, an expert, a judge, or practitioner works, but it's not widely understood beyond them. And human rights is all too often masked by the technicalities of the law, how it is applied, promoted, or defended. Framed in another way, if there is no means of conveying law deeper altruism, the technical side of the law itself becomes the main barrier to any proper understanding of human rights. We notice how politicians, representatives, will regularly speak of ethics, values, of a Western liberal order. By not referring to the law or its jurisprudence, it is as if they don't realize there is a law there. And this is our challenge in the human rights world. How do we relate in a manner made more accessible to everyone, not just the mechanics of human rights, which are important, but also a sense of why it's so crucial that more people know something about them. After all, if you, as an individual, don't know your rights, how can you assure yourself that your legal protections are being upheld? Especially in the face of those who may doubt the validity of rights, or worse, seek to rob you of them. The key to making our human rights world simpler for others to understand lies in offering less technical explanations. But we are also helped by the clear-cut expression of many of those rights. The inherent right to life, and that no human being should be deprived of it arbitrarily. The right of human being not to be tortured, a prohibition now so absolute no circumstances could ever justify it. It is no coincidence that the Universal Declaration of Human Rights remains the more translated document in the world, written as it was in a style that has made it so easy for us to understand, but also because it touches in us something we should all yearn for, a universal sense of belonging. In the center of our work, and this must come through in our speeches, expert decision, and judgments, we find the most exquisite human recognitions, that we belong to one community, to one family, irrespective of nationality, of race, religion, ethnicity, color, gender, or sexual orientations. That our happiness, our security and humanity is assured when we serve others, the one family, and not just part of it. Thank you very much for your attention, and thank you for the work you will do during this week in Geneva for the best of our world. Thank you very much.
Thank you very much, Rector Flückiger, for your very important and especially inspiring remarks. I think it's so important that we reiterate that human rights are for everybody and nobody could be deprived arbitrarily for that. So thank you for your presence here, your interest in this tribunal, and I think what you have said for us is really the fil rouge during this session of the tribunal. So many thanks. So sorry, I will take the floor a little bit to to explain what the tribunal is. So the Turkey Tribunal is a so-called opinion tribunal. An opinion tribunal is neither an ordinary, regular court that falls within the judicial order of a state, nor a court set up by an international organization. It is an extraordinary court, born out of determination on civil society that take the initiative and is actively involved in it. It serves as an instrument and platform to give recognition, visibility, and a voice to the people who allege suffering violation of their fundamental rights. There is a long tradition to the opinion tribunal, and several have already been held in different parts of the world on different topics. Other opinion tribunals are tasked with examining, using a judicial method and rules of law applicable to highly problematic events or situations that affect or are of serious concern to people, of group of people, or to society as well. The objective of an opinion tribunal is twofold: alerting public opinion, alerting stakeholders and policymakers, and contributing to the advancement of national and international law. Over the following days, 6 rapporteurs will present their findings on allegations of human rights violation in Turkey, with a focus on 6 topics: allegation of torture, abduction, press freedom, impunity, judicial independence as well as access to justice, and crimes against humanity. 15 witnesses will testify about their personal experience in this regard. After the presentation of each report and the hearing of the related witnesses, the tribunal will ask questions and to the rapporteur and to the witnesses. A slot is reserved in the schedule for a potential intervention by a representative of the Turkish government. The Turkish government has received an invitation to attend the session and has received copies of the reports that will be presented. The hearing is public. The hearings are public and can be followed via live stream. We also have 5 independent observers who will follow the proceeding and report on the process. Maria Nerena, who is member of the European Parliament, Kathleen van Bemte, politician, member of the Dutch-speaking party and member of the European Parliament, Klaas Grinell from Sweden, director of the Center for European Studies at the Göteborg University, Philippe Marquez, president of MEDEL, magistrat européen pour la démocratie et les libertés, and Mariana Kakunaki, award-winning journalist. She has conducted several joint investigations which followed journalists from Germany, Norway, Switzerland, producing and publishing cross-border reports. At the end of the session, the tribunal will be called upon to formulate an opinion regarding the question raised on the conformity of the action of Turkey with international human rights and international humanitarian laws. The tribunal has no investigative powers and will not establish criminal or civil liability. Its advisory opinion is not binding. However, it will have high moral authority and could provide legal tools for all those victims, lawyers, judges, civil servants, NGOs, which on the ground wish to take action. The tribunal and its judge are entirely independent and operate in full transparency in accordance with the rule of procedure and with respect to the international standard of a fair trial. All judges have a long tradition of delivering very high quality work and acting independently. So let me briefly introduce them. Justice Dr. Johan van den Westhuizen, South Africa, former judge of the Constitutional Court of South Africa, professor at the University of Pretoria and the founding director of its Center for Human Rights, also acting judge at the Court of Appeal of Lesotho. Angelita Bayens, Belgium-Colombian, Vice President of the International Advocacy and Litigation at Robert Kennedy Human Rights Center, Adjunct Professor of Law at Georgetown University Law Center, and former Political Affairs Officer at the UN Department of Political Affairs. Professor Giorgio Maliverni from the University of Geneva, so see you in university. Professor Giorgio Maliverni, former judge at the European Court of Human Rights and former member at the Venice Commission for Democracy Through Law. Professor Dr. Lady Biancu, Albanian, Associate Professor of the Faculty of Law and Institute of Political Science at the University of Strasbourg, also former judge at the European Court of Human Rights and at the Venice Commission for Democracy Through Law. Dr. John Pace, through video, so you will see him in a few minutes. Dr. John Pace, Australian, Director of the Diplomacy Training Program of the Australian Human Rights Centre at the University of New South Wales, former Chief of the Human Rights Office of the UN Assistance Mission to Iraq, and Head of Special Procedure of the Human Rights Council. And so myself, I am Françoise Tulkens from Belgium, and also a former Vice President of the European Court of Human Rights and Professor at the University of Louvain in Belgium. On the past weeks, and I realized that I witnessed that, over the past week, the judges have been thoroughly preparing for the tribunal with the aim to reach a fair, high quality, and clear opinion. The tribunal has the assistance of 3 registrars, and they are there, and I want to congratulate them and to thank them very deeply. Professor Dr. Clara Bourbano Herrera, Professor of International Law, International Human Rights Law at Ghent University. Yasmina El Kadoui from Belgium, lawyer at the firm Van Steenburg and Advocaat at Ghent. Esther Thijskens, senior lawyer at the firm Van Steenburg and Advocaat in Ghent. There is also accompanying this tribunal research division, and this research division is here with Martin Vermeer, who is in the assistance. Thank you so much. So, just before starting, silence maybe is the greatest enemy of fundamental rights, and that's for us really very important. It's not only a slogan, it's a principle. Silence is the greatest enemy of fundamental rights, and it is the founding principle of this tribunal. The rapporteur and the witnesses have made the choice not to remain silent, but to share, respectively, their objective findings and their personal experience, which is a very important situation. The tribunal will listen very carefully to all of them, after which a judge will deliberate and formulate their opinion. And through this opinion, I think the tribunal will also try to break the silence. So let's start now. Let's start because we have a very, very full day today and the following day as well. We will start the first session with torture. Torture is the first subject matter, is the first topic we deal with. And in this respect, we will start with you, Professor Sottas. You will make your presentation of torture in Turkey. You have 1 hour. It means, if you agree with us, 30 minutes of presentation, and not 30 years, but deserve 30 years. 30 minutes of presentation and 30 minutes for discussion and question put by the tribunal. So, Professor Sottas, thank you very much, and you have the floor.
Madam Chairperson, honorable member of the court, excellencies, ladies and gentlemen, this report aims to provide an answer to the question addressed to the Turkey Tribunal about torture, which are: who are the targeted group? What is the purpose and motivation of the perpetrator? Is there a pattern in the way torture is inflicted? Is being used systematically? Is it an organized practice? Is it torture tolerated within the security system itself? And what is the involvement at the central governmental level? Before to address this question, I will go through some topics. The international legal context. We will concentrate only on two instruments, which is the Convention Against Torture at the international level and the Convention on Human Rights at the European Convention on Human Rights at the European level. I will not go through the definition of torture because everyone here knows what it is, but I would like just to remind some points. The first one is that torture, as defined in the convention, is a minimal. I mean by that, it's the minimum that a law should include in the penal code of the country. You can enlarge it, but you cannot reduce it. I mean by that, giving an example, in Uruguay, ill treatment has been included in the torture definition and not as a separate, which is absolutely acceptable. But what you cannot do is the opposite, is when an act is fulfilling the criteria of this convention to consider it as ill treatment or degrading treatment, etc., to judge it under another category. The second point is the prohibition is absolute. And in this sense, no exception or derogation are allowed, neither for threats of terrorist act, terrorist attack, violent crime, or horrendous crime. According, that is in Article 2.2 and 2.3. According to Article 4, the criminalization of torture, each state party to CAT must ensure that all acts of torture are offenses under the criminal law, with the condition I've just precised before, fulfilling this criteria at least. Disciplinary sanction, unlike or suspended prison sentences or amnesties, are not in accordance with this provision, at least as sentence of few years of prison has to be inflicted to a perpetrator of torture. This is comments coming from the Committee Against Torture about the necessity to have imprisonment sanction. Another point, because we have not mentioned the question of the involvement of the official in the perpetration of torture, but it is important to remember where state authority know or have a reasonable ground to believe that acts of torture or ill treatment are being committed by non-state official or private actors, and they fail to exercise due diligence to prevent, investigate, prosecute, and punish such non-state official or private actor, the state peer responsibility. General comment from the CAT also. The European Convention of Torture also has clarified some point. There is a prohibition of torture under Article 3, but no definition. But the jurisprudence of this tribunal at the European level has given a very consistent elements about the different points. There are two I would like to pass by. Is one, the obligation to investigate whether torture or inhuman or degrading treatment or punishment has been committed, on the obligation to prevent such a treatment from being inflicted both by state agent and by private party. It is in line with the CAT, the Convention Against Torture, and the Committee Against Torture, but it is also in line, I think it's important to remember that, with the other regional court. For instance, this principle has been established also in the Inter-American Court already in the 1988 cases Velasquez Rodriguez versus Honduras, and confirmed the following year. The question of the burden of the proof. On two occasions, the convention, the European Convention, in the Aydin versus Turkey case in 1997, and the Salman versus Turkey case in June 2000, torture in cases of torture in detention, the European Court of Human Rights has concluded that even though the burden of proof lies with the victim, if the victim can indicate a reasonable suspicion that he or she has been subjected to torture, inhuman, or degrading treatment while deprived of his or her liberty, the government will have to provide evidence to the contrary. These, I think, is just some elements. We will come back with some question later on. I would like now to turn to statistical information from the Turkish government. We have decided to use the Turkish, I don't see the, maybe I have to move that here. Yeah. Here, I'm sorry for the judges, you don't, oh, you see it, okay, sorry. So, as you can see, the first column is in fact about cases which has been recognized as cases of potentially torture commission. Non-prosecution, well, the order, I think, are very clear. What we have tried to work on, and we have done a diagram to clarify that, is from the cases happening in a country, what is the case in Turkey, we have no elements. It's an unknown number for obvious reason. It's a hidden crime, and the victim themselves are reluctant. We have several testimonies, particularly in case of rape, where they decide not to speak in order to avoid the repetition on this crime against them, and also for the family, for family reason. But also the complaints. We have here in the statistic, you have it before, we have the cases which have been recognized as having elements to be judged as potential cases of torture. But we know, and that it's based on the comment of the CAT in his 4 periodic reports on Turkey in 2016, a significant disparity between the high number of allegations reported by non-governmental organizations and the data provided by the state party in its periodic report, suggesting that no allegation of torture have been investigated during the reporting, not all allegations of torture have been investigated during the reporting period. We had to that some denunciation coming, for instance, from non-governmental organizations, like, for instance, the Human Rights Association in Turkey, a very well-respected organization formed in the 80s by a former victim of torture. And for them, they calculate that in 1 year, in the period for 2000 to 2015, they arrived to a number of cases of 2,063 cases of people denunciating, cases of people denunciated to them. Now, we have also to recognize that this association is not receiving all the cases of the country. So the cases they have received are rarely denunciation of people who came to see them specifically. So it's why we are considering, but it's an estimation, that's probably the complaints are closer to 3,000, which is more or less in line with what this organization has taken into consideration, than the one given in the first column you have. So we can estimate that an average of 1,421 cases open annually as potential torture cases represent about half of the number of complaints for torture presented on behalf of the victim. Some of these complaints are just not, like I said, not recognized by the prosecutor, considering that they are not fulfilling the thing. After, if we continue with the indictment, we realize that on the cases open, 1,421, only 177 have been taken as cases open. So we have only 12%. If we compare to the estimation we have done on complaint, I think it's quite low. And the last question is the imprisonment. Since we consider that the punition should be at least some time of imprisonment, we can estimate that we are about 1% of the cases open and 0.5% of estimated complaint. Remarkably, the number of cases open have clearly declined since 2015. Compared to 2013, the number for 2018 is down by nearly 50%. And there is no indication that the number of cases are dropped in this period. On the contrary, information received are giving the opposite view. The only explanation that is plausible is that the reduction of the reduced will to prosecute torture on the part of the prosecutor. It is also interesting to compare for the whole period, 2010 to 2019, the number of cases registered as potential cases of torture and ill treatment on detainees with the potential cases of public official victims of violence or threats to prevent them from carrying out their duty, following the wording of the Article 265. For the first category, we found sorry, I have only the second one in the blackboard. For the first category, we found 28,768 cases of torture and ill treatment for violence. But for the second one I've mentioned, the public official who has been threatened or who has been a victim of violence performing their duty, we have 1,732,767 cases of persons who have denounced such violence against them. Now, we have used these figures, and it's the last time I would rely on statistics. Now, we are going now to use, to analyze the situation only, or mainly, but only, almost, the report about Turkey, torture in Turkey, based on the different report proceeding from institution to covenant instrument to which Turkey is party. First, the report on the CPT, the European Committee for the Prevention of Torture. Second, the report from the UN Committee Against Torture. Third, the Council of Europe, the memorandum of the Commissioner for Human Rights. Fourth, the Special UN Rapporteur on Torture, and the report of the Office of the High Commissioner for Human Rights. For sure, here we have many, many quotations, and I will not take all of them, it's impossible. And secondly, I think it will be quite heavy. But concerning the CPT carried out 31 visits in Turkey from 1990 to the end of 219. 7 of them were periodic visits, 24 were ad hoc visits. The ad hoc visit is when there is a case bring to the attention of the court, the other one are the regular one. For the report corresponding to the visit in August 2016 and April 2018, no authorization to publish was given by the Turkish government. Just to explain this mechanism, the CPT is based on the ICRC system. The members of the committee are visiting places of torture in different countries and preparing a report for the government. This report normally is confidential for the government. I say normally because there were a remote possibility to publish it in case of a refusal of the government to be active in the process of working with the CPT. But in fact, what has happened is a group of NGOs, when the first country which has ratified the system has the initial visit, was to insist to this country that they should have to publish themselves the report they have received as a way to show the transparency, but also to help to redress the situation. And that became the practice. The fact today not to publish reports is per se an evidence that this report contains elements that the government doesn't want to be public. And we cannot use it, but I think it's important to take it into consideration. So now I will go to one visit, recent visit. I've decided only to take the last 5 years because we have some visit from the 90s I think are less pertinent today. On May 217, the CPT delegation received a considerable number of allegations, I'm quoting here, from detained persons, including women and juveniles, of recent physical ill treatment by police and gendarmerie officers in the Istanbul area and in the southeastern Turkey. Most of these allegations concern excessive use of force at time of or immediately following apprehension, as well as beating during transportation to law enforcement establishment. In Istanbul, the delegation received detailed and consistent account from the detained person, including women, interviewed independently of each other, that they have been taken by police officer to a partly derelict building in the city center where they were subjected to heavy beating and severe sexual humiliation, in particular by officer of a mobile intervention unit called Yunus. The following visit was in May, 6 to 17 May 2019. I will not go through, but just mention that it confirmed the observation of the first visit, but they insist also on the question of the brutality of this mobile motorcycle intervention called Yunus. Now I will go now from the report of the Committee Against Torture. In its concluding observation in the fourth periodic report of Turkey in June 2016, the committee, quote, "The committee is concerned that it has not received sufficient information on prosecution for torture, including in the context of cases involving allegation of torture that have been the subject of decision of the European Court of Human Rights. Further, the state party has undertaken many investigations into allegation of ill treatment and excessive use of force by officials that has resulted in a relatively few cases of disciplinary sanction and in fine and imprisonment in only a small number of cases. The committee is seriously concerned about the numerous credible reports of law enforcement officials engaging in torture and ill treatment on detainees in the context of the resurgence of violence between the Turkish security forces and the Kurdistan Worker Party, following the breakdown of the peace process in 2015, and terrorist attack perpetrated by individuals linked to the so-called Islamic State in Iraq and Levant. The committee is further concerned at the reported impunity enjoyed by the perpetrator of such act. Council of Europe, here it's a memorandum of the Commissioner, I'm quoting, the memorandum is dated 7 October 2016. As regard ongoing criminal proceeding, among the most immediate human rights concern are the consistent report of allegation of torture and ill treatment. The Commissioner does not automatically give credence to such allegation, but observes that the extension of custody period to 30 days, practical changes to procedure for obtaining medical report, and drastic restriction to access to lawyer, as well as limitation and the confidentiality of the client-lawyer relationship, contribute to the persistence of such allegation. The Special Rapporteur on Torture, the UN Special Rapporteur on Torture, note with concern that there seems to be a serious disconnect between declared government policy and its implementation in practice. Most notably, despite persistent allegations of widespread torture and other form of ill treatment made in relation both to the immediate aftermath of the filing code in 2016, and to the escalating violence in the southeast of the country, formal investigation and prosecution in respect of such allegations appear to be extremely rare, thus creating a strong perception of de facto impunity for acts of torture or another form of ill treatment. The report of the Office of the High Commissioner for Human Rights. There were two reports published by the Office of the High Commissioner, one in February 2017 and another one in March 2018. The High Commissioner, I will just say High Commissioner, not the full title. The High Commissioner documented the use of different forms of torture and ill treatment in custody, including severe beating, threats of sexual assault, actual sexual assault, electric shock, and waterboarding. On the basis of numerous interviews and reports, the High Commissioner documented the emergence of a pattern of detaining women just before, during, or immediately after giving birth. In almost all cases, the women were arrested as associated of their husband, who were the government's primary suspect for connection to terrorist organization, without separate evidence supporting charges against them. Now, there are, like I said, many other, but the time is going, so I will just mention rapidly. We have analyzed the evolution of torture, and we have found three periods. One is just following the coup d'etat in 1980. This was a period, we can say, of generalized and brutal torture, not only against political opponents only, like the Kurdish activists, but also violence appears to be inflicted even on juveniles, mainly as punishment, but not automatically with the intention to obtain information or confession. At the beginning of the 21st century, positive legislative changes are made. In 2003, the new Erdogan government officially declared that it will apply a zero-tolerance policy toward torture, and most of the observers, such as myself, I have paid several visits when I was Secretary General of the World Organization Against Torture, and I saw the change. Most of them have noted an improvement, even if we cannot say that torture has completely disappeared at this moment. But in the last 10 years, there have been an intensive resurgence of torture, and the chance that perpetrator will be punished with a sufficiently severe imprisonment is nearly non-existent. Now we would like to evaluate some of the arguments of the Turkish government denying the complaints with the following argument. One, the fact that the complainants are opponents of the regime and therefore have an interest in spreading false rumor and accusation. Two, the lack of medical evidence on most of the torture complaints. And three, the fact that the complaints examined by the court very rarely lead to a conviction. The first decisive element is the jurisprudence of the European Court on Human Rights. Turkey has been condemned 441 cases for violation of Article 3. As far as torture is concerned, it can be qualified as a repeat offender. But we have also established that each year in Turkey, on an average of 13 alleged perpetrators, you saw the statistic at the beginning, who are sentenced to imprisonment, we can see by contrast that an average of 18 convictions per year in which the Turkish state is being held accountable by European Court of Human Rights for a violation of Article on Human Rights. So the fact that there are more cases under scrutiny by the European Court than the one sanctioned by Turkey is quite appalling. The question of the lack of medical or poor report when requested by the victim is also underlined in several reports. In the case Arslan versus Turkey, 20 October 2015, the medical report which were issued in respect of the alleged victim of torture, quote, lack details, fall short on both the standards recommended by the CPT and the guidelines set out in the Istanbul Protocol. In view of the court, the public prosecutor should have questioned the quality of the medical report before basing his decision on them or should have requested a further examination. There are some other on medical. I will move now to the other point, is the fact that the fact that very often the procedure is taking such a time, and for reasons which are not clear, that it end up with the problem of time limitation. And I will quote the court again, the case Shakir Kashma, Turkey, November 2015, where the court has noted that the absence of evidence for torture allegation can to a great extent be attributed to the Turkish state itself, to the failure of the public prosecutor and the judge, who both failed to proceed with a prompt investigation, given that the evidence was collected more than 2 months after the end of the applicant detention in police custody. These two elements for me are quite clear to respond the justification of the government. The second decisive element is that torture applied in a large scale. The number of reports from the international bodies and mechanisms to which Turkey is party, I think, clearly show that torture applies on a large scale. The third element is that the perpetrator of torture has not been punished. But when we see the jurisprudence at the European level, and the figure as just mentioned in the intervention earlier, and the Annex 4 that you have to this report, with some information about 10 flagrant cases which were not properly investigated, we can also consider that this element is not relevant. Though, in conclusion on this point, the number of judgments of European Court and the clarity of the violation found, the detailed and repeated report of the international body, which we have quoted in detail in the report, and certain severe cases of torture that did not lead to punishment, force us to conclude without any doubt that torture is effectively a profound evil in the Turkish state nowadays, that occur frequently and whereby the perpetrator of this crime were rarely punished by imprisonment. There are two, I still have 5 minutes. We have some other questions. Who are the targeted group of torture? What is the motivation behind torture? Is there a pattern in the way torture is executed? We have found 4 groups: the Turkish movement, the Kurdish movement, the Gulen movement, ordinary criminal, and juveniles, who have cases, showing this type of targeted group. But we have also identified 3 groups, not based on the affiliation or the fact that they are belonging to this type of organization, but based more on the way they have been arrested and repressed. So we have created some groups, if we can call it like that, concerning people arrested mainly to convince them to become police informant. Second, person presumed member of the PKK or extreme left-wing organization and the Gulen movement who are not arrested but abducted in Turkey or abroad and transferred to Turkey after the abduction. This is another document which will deal with that, so I will not enter. And the case I've mentioned just before, the wife of arrestment, which was underlined by the High Commissioner for Human Rights. About the motivation behind torture, they will cover, I will say, all the possible purposes of in the definition of the convention. Obtaining confession, the suspect must sign a statement in which he incriminates himself. Obtaining information, there will be torture to oblige the victim to give names of other members. Punishment occur after confrontation in period of violence, but also on suspect sexual abuser, and on children, on juvenile detained, as a type of normal punishment But in this normal punishment, like we will see, they apply falaka, they are using some absolutely unacceptable treatment and torture. Discrimination, as far as Kurdish people are concerned, discrimination is a purpose. I will not develop, but torture is part of the discrimination against this group. Now, is there a pattern in the way torture is inflicted? The way in which torture is being carried out differ in time. What we have often seen put forward in the report and testimony is that specialized persons are involved and whereby this specialized person make it clear to the victim that they are fully aware of what they are doing and that they can go on for a long period without killing the person in question. This expertise seems to be omnipresent among the personnel of the Security Directorate. Those testimony about torture allow us to conclude that there is a systematic and organized use of torture. The answer to this question is divided again. Is torture a practice limited to a spontaneous reaction of certain individual security officer, and is it organized? Here we have already the answer since, like I mentioned, specialized people intervene. So that supposes an organization. How frequent is the use of torture toward a person kept in police custody? So can it be regarded as systematic? In police custody, we cannot have figures complete about how many people are detained and how many are subjected to torture. But what we can say is on the groups we have described are targeted by the authority, yes, here we can consider there is a systematic practice. Is torture a practice that is tolerated in the security system itself? And what is the involvement of the central government level? On these two last points, and I'm just coming to the end, the number of disciplinary sanctions, this is the first part of the last question. Torture is a practice that is tolerated within the security system itself. The number of disciplinary sanctions is very low, between 1 to 4%, both for torture and ill treatment. The figures submitted by the Turkish government concerning disciplinary sanction in cases of torture certainly do not justify the assertion that through disciplinary action, the security services are reacting to torture in a current and rigorous way. The contrary is true. Torture is tolerated in the security system. That's the only logical conclusion we can make. And what the involvement, which is the central point, of the governmental level. Here we have to make a distinction. On human rights issues, specifically on torture, the state authority may be held responsible for acting against the law and the international obligation, for committing an act of torture, giving order to perpetrate this type of violation, or actively covering it up. Some public declaration, like the one of the then Minister of Economy, Nihat Jebejski, in July 2017, about the plotters of the failed military coup, Patin said, quote, "We will put them into such a holes for punishment that they won't be able to see the Son of God as long as they breathe. They will not see the light of the day. They will not hear a human voice. They will beg for death, saying, 'Just kill us.'" And another declaration on October 2017 by Mehmet, AKP member of the parliament and head of the prison commission in the Turkish parliament, stating, "We will not investigate the torture allegation against FETO member." But although this message raised serious questions about the sincerity of the expressed government policy, they are not, for our point of view, not sufficiently binding and clear to conclude that the government, by direct instruction, bears an explicit direct responsibility for the continuing of torture. We cannot prove this kind of responsibility on the part of the government. But the responsibility of the government also includes an obligation of due diligence which means taking the necessary measures, among others, to ensure the respect of the national and international regulation, securing a full and efficient investigation in case of violation, adequate measures to prevent the occurrence of torture, integral reparation for the victim, sanction of the perpetrator in order to avoid repetition of this crime, and so on. Two elements prove that the government is not taking the requested measure to fulfill its obligation. The first element is the high number of cases. The second one is the impunity of the perpetrator. The Turkish government did not create an independent national prevention mechanism like he is supposed to do under the OPCAT he has ratified, although the government received clear and detailed recommendations about these from international official institutions whose legitimacy was and remained legally recognized by Turkey. Two, the government reinstated system of authorization and immunity, although already in the past the European Court of Human Rights made clear that this was unacceptable and would lead to more torture, and although this system are clearly against the obligation provided by the European Convention on Human Rights and the Convention Against Torture, and the government denies documented and proven lack of independent medical control, which is essential to prove and to prevent torture. These two observations bring us to inevitable conclusion that the central government bear full responsibility for the systematic and organized use of torture in Turkey and the nearly non-existent prosecution and punishment of it. Madam Chairperson, members of the court, this is an executive summary of our funding and torture. Victims who have accepted to testify about what they underwent will now answer your question and provide more elements in the course of this session. Thank you for your attention.
Thank you very much, Professor Sottas, for your very extensive and robust report. We have to remind that prohibition of torture under international human rights law, it's an absolute prohibition. That's, of course, very important. And what I think is very important that it exists in the European Convention of Human Rights and under instrument an obligation to investigate. The obligation to investigate is central in this field. How can we reach the reality? The reality through an investigation. So the obligation investigation, and you have seen that in the case of the European Court of Human Rights, many cases concerning this obligation. And also, as you explained in the beginning, the reversal of the burden of proof, it goes together, of course. So thank you very much, and I think it's very important because torture is maybe one of the most important rights, human rights, concerning integrity of the person. How can you enjoy other rights if you are under torture? So now we will start. Thank you very much again for this excellent report, very illuminating. We will start the question time, and maybe I will give the floor for the beginning to Justice Pache for the first question. Ah oui, pardon. Voilà. He cannot be with us physically, but he is there.
Yes.
Justice Passé, you have the floor.
Thank you so much. I'd like to thank also the rector of the University of Geneva,
Oui.
Who made the point, which I have lived, that indeed Geneva is something like the heaven for human rights. I guess it has seen a few of the inhabitants of all levels of post-death, not just heaven, but in any case, thanks for the environment in Geneva that has enabled such a lot of work to be undertaken in impossible circumstances. Thank you also to Eric for superb report from the technical point of view anyway. I have just a few clarifications to seek, if I may. Eric, could you give us an idea of the methodology that you followed in drawing up this report, please? It has a kind of, it reflects a variety of styles and sources, but thanks to your presentation I am a little bit more clear. But I wonder whether you could just briefly give us an idea of the methodology that was followed in drawing this report up, please. If you wish, Baroness, I can present my other questions to the rapporteur, but depends on you.
Okay, I'll answer that first. Okay. Like I've mentioned in the introduction, we have used first the elements or the data provided by the government itself. For instance, the figures I gave on the question of the number of cases of people who have denounced torture, who have been, and the indictment, and the people who finally has been sanctioned, that is based on a table that you can find on the Minister of Justice of the country. But to that, we have also looked at what are produced by other sources, like, for instance, the Committee Against Torture, denouncing the fact that apparently there were not enough investigation, and look at different type of organization, like, for instance, the human rights organization in Turkey, which is documenting. This organization is a very well recognized organization formed, like I said before, in the 80s by former victims, and they are documenting cases, producing reports. So we have tried to compare these figures with what they have as figures, particularly since the UN clearly said it is not complete what you are producing. We have also used the official institutions, 3 levels, the official data from the government, information coming from the organization, and here you have a long list of organizations as sources of this type of information we have cross-checked, and report of international institutions recognized by the Turkish state. And most of the elements are elements which are, I would say, in the 3 level, with the exception of what I've mentioned before, some element that the government is not producing deliberately, I would say. So I don't know if I'm answering the question, but it's we have tried to look at the different potential sources of information and what we found reliable, and particularly putting an accent on the official one.
Very much. John?
Yeah, thank you very much, Eric. That's very helpful. May I just take you now to to your report, and specifically paragraph 112 on the involvement of the central government in this issue. In that paragraph, the report states that it says, involvement and responsibility must be considered as synonymous. The question is simple. Important and weighty is the central government of Turkey responsible for the systematic or organized and tolerated use of torture with nearly no risk of prosecution of the perpetrators? Then it says, note that when the first reports of a positive evolution in the use of torture were made some years ago, the government claimed responsibility for that. And then this is my, wouldn't it be legitimate then for the opposite to happen now? It's that last sentence that I need some clarification about, if it's okay with you, please. I didn't understand that sentence at all.
Okay. What the sentence you refer?
Pardon?
Well, now the point is, at the moment, like we mentioned before, we have had a period where the government announced its zero policy
Yeah.
zero tolerance policy.
Yeah.
And at that moment, we were just waiting to see, you know, and we were controlling that. And we
Yeah.
said, it's true, they have changed. And
Yeah.
we were documenting less cases, etc. So if at that moment we have considered that the government was responsible for this positive change, at the moment where we see that the situation is changing completely, we also have to see that not giving direct order, like I said, but by tolerating the government and the contrary is in the same line responsibility for this negative change.
I see.
I don't know if
So we expect the government to say, the government said when things were going better, as it were, to take credit for that. And when things got worse again, the government should have said, oh, well, things are not so good now. Is that what the sentence means?
Yeah, to a certain extent. And the change of attitude also, the refusal to have the report published and so on, prove that they have entered in a new phases, if I can say so, of hiding things and presenting information which are at least not completely true, when in
Yes.
fact in the precedent we have other type of information coming from them. So it's why
Thank
we're
you.
saying if they were taking advantage of the positive change,
Taking credit.
now
yeah.
they have to recognize.
No, I am very grateful for that clarification, because it helps also to understand the kind of trends that were manifest in these and all this period. I have one last question, if it's okay. This refers to the part of the report where a reference is made to the CPT visit of 2017, page 24 of the report. It states, it is noteworthy that only a limited number of allegations of physical ill treatment by law enforcement officials were received from detained persons who had recently been detained on suspicion of terrorism-related offenses, in particular in connection with the military coup attempt of 15 July 2016, which constitutes a stark contrast with the findings of the August-September 2016 visit. Now, also, with regard to the CPT's visit of 2019, the report states that allegations about torture came mostly from persons suspected of ordinary criminal offenses. But in page 30, the report quotes the UN Special Rapporteur on Torture, who reported in 2016 to have received numerous allegations relating to torture in the aftermath of the coup. So Turkey's position was also that most people who were interviewed by the Special Rapporteur were terrorists, suspects. Now, can you explain the difference between the CPT report and the report of the UN Special Rapporteur on this issue? Why did the CPT receive a limited number of allegations of terrorism-related suspects, while the Special Rapporteur received numerous allegations? Can you clarify why the CPT reported a limited number of allegations of ill treatment from persons detained on suspicion of terrorism in connection with the coup? You know, the question is centered around the difference between a suspected terrorist and torture of other offenders, if you like.
Okay, well, I have not a clear explanation why there's the discrepancies between the two reports belonging to two people at the servicing the UN. I can just have some hypotheses. One hypothesis is the fact that on some of the opponent, there were, I have said, and tomorrow we will have more element on that, denunciation of abduction and torture under abduction, you know, which means that torture were not officially occurring in the end of. And secondly, at the moment of the coup, there were a lot of denunciation, particularly because, and here I think all the reports are mentioning that at the moment of the coup, there were violence. So there were denunciations coming all around, and Turkey, and we have some elements of head of jail before the visit of some groups like the TPT or Special Rapporteur, asking the director to make sure that situation will be clean enough for the visit. So it has happened, but I'm not absolutely, I was not part of the visit, nor of the one of the Special Rapporteur, nor the one of the CPT. And the CPT has probably received some information also here in Geneva. But what I mean is here probably there were some instruction to be a little bit, after a certain time, to be a little more cautious about the fact that opponent has a voice, and they should take care about the one who can make declaration in the next future, you know. That's my explanation. And probably also when the Special Rapporteur went to the place, he got some different information, maybe from the same person, but here, again, it's purely supposition.
Thank you very much. Maybe if you agree now, I will give the floor to the other judges, because time is running. But so maybe the best thing to do now is you can put your question and you will give answer all together. Alors, lady, we will start.
Thank you, Madam President. I have a question concerning the evidence, because the Turkish government is referring to the fact that there is not enough evidence for the prosecution of acts of torture happening in prisons and detention centers. Do you think you've referred to the fact that judges or prosecutors do not insist on the quality of medical examination to people detained? But do you think there is a kind of independent system of medical examination? So are doctors who are sufficiently independent in order, on the side of the professional aspect of it, able to conduct a thorough examination of acts happening at the hands of the authorities? Thank you.
Maybe you will give answer to all the questions. Giorgio, yes. Justice Malinverni.
Yes, many thanks, Mrs. President. I have a question on the difference between torture and ill treatment. It refers to Appendix 1 in the statistics, because the Turkish legislation makes a difference between torture and ill treatment. For instance, Table 1 refers to torture, which is Article 243, and Table 2 refers to ill treatment, Article 2045. In my view, this distinction is very difficult to make, and I would like if you could comment a little bit on this. Upon which criteria did the Turkish authorities rely, or the body which examined the cases? The European Convention on Human Rights mentioned both in Article 3, but most of the judgment arrive at the conclusion that there has been a violation of Article 3 without making a distinction. So could you comment on this a little bit, please?
Thank you very much, yes. Justice van der Westhuizen.
Thank you, President. I had two questions, but the first one has, to a large extent, just been asked by my colleague Malinverni, and that is also generally in international human rights language, starting with the ICCPR, people talk about torture or cruel, inhuman, degrading punishment or treatment, and thereafter just use the word torture. So is there a distinction? And if there is, it is virtually the same question. I'm sorry, if there is, when you mention cases and numbers, etc., are you talking about torture in the narrow sense or the wider concept including ill treatment, or is there no distinction in the first place? Then my other question is, in law, it is very important to hear the other side, audi alteram partem. I understand from the organizers that the Turkish government has been invited repeatedly to participate in these proceedings and to present their case. As far as I know, they have not accepted the invitation. This leaves me, and I suppose my colleagues, that we hear the reports. I respect your independence, but still to some extent we hear one side. So if I can be unfair to you, apart from the three arguments that you mentioned coming from the Turkish government, namely one, its political opponents of the regime, two, no evidence, medical evidence, three, a very low conviction rate, etc. If you were here today, briefed as a professional lawyer to argue for the Turkish government, what would you say? If there anything you would add to those three arguments? Is there any conceivable point on their side that you could mention, whether you agree with it or not? Thank you.
Thank you very much. Justice Bayens?
Thank you, Mr. Sottas. I just have, in addition to what my colleagues have raised with you, my additional question would be in terms of the purpose of torture, and you identified several categories, including, for discrimination in particular. So I would like to ask you to elaborate a little bit more on that, and particularly if, in addition to the specific motivation based on ethnicity, specifically the Kurdish ethnic identity, if in your research you could identify other grounds of discrimination among the cases of torture. Thank you.
The floor is yours. Yeah.
Okay, sorry, I'm afraid that in the 5 minutes
You will do it.
Okay, the first one I already answered about the question of the methodology. The independence of medical doctor. Here, for sure, there are some independent doctors in Turkey. Would be completely unfortunate to consider that it's not possible. But if, maybe I think, yes, I mentioned it when I presented because I dropped some pieces.
Yes, yes.
But on one clear passage, the commissioner, or the European Commissioner, mentioned the fact that most of the people of the board and the doctor, etc., in jail have been moved. So I guess there were independent doctors. Because, the Istanbul Protocol is quite clear, the way you have to analyze the scale, the way you have to analyze the currents between what the victim is telling you and the things you can find. This type of evidences should be produced by the doctor. It should be said, no, there is no coherence, or on the contrary, there is full coherence, and in this case, or at least a big coherence. But what we have is the fact that doctors sometimes, well, that is the denunciation of a victim, we will come on that after, he said that he haven't seen the doctor, but he received a report. And he said that report I never, and you will probably hear also some of the victims here, who said, we were not signing this document, but we will pretend to be the one who have accepted that and that and that. So I think here the question is, if at this moment there are some doctors who are doing, to speak clearly, their work properly, I think so. But to which extent their report are after used by the between bracket, the general power. And one thing that was observed by even several of the visitors is the fact that the victims said the guardians were there when the doctor was coming. Again, it's not supposed to be the situation, and it's basic in the Istanbul principle and the CPT principle, is why the European Court in several occasions said, sorry, but it's not in line with. So, I don't know if I...
Maybe
the difference between...
degrading and torture.
Yes. Well, here you are right sometime, and particularly at the European level, there is a tendency to use the both prohibition because the two things are prohibited anyway. So in the report, they put that the prohibited torture and ill treatment have been perpetrated. But we have tried to disaggregate, and we were helped by that, by the fact, like it was mentioned, that the code is even having certain level of torture and ill treatment. Now, after that, and I cannot advance too much, and I haven't quote even that part, but we have some suspicion, and more than suspicion, that the opportunity sometime is the reason to accept or not accept to put that as a torture. You see, when the victim is presenting his complaints, or his lawyer or his representative presenting the victim to minimize the level of suffering. And here you enter, because the difference at the international level is, for most of the court, the question of the level of suffering inflicted. And some cases we have had scares which appear of a situation where the doctor has not found that it was enough for torture. So here, I guess there is a certain level of interpretation. And here, yes, we think that there are pressure on the different people in the detention center, in the police, and so on, at this moment to minimize. Now, the question about the fact that we have not a counter, you're absolutely right, and it's not, I have to say, to be in a form of tribunal, it's not the most pleasant, because you have to consider that we have not the other part. When you are accused and the other is answering, it's much easier, because you know that who is doing his part. So what we have tried is to invite the government to be part of the process. We have sent this report to them and said that there will be a time for them. And even I was invited to speed a little bit up about the report, because it has to be signed by that date at the government to give the time to analyze. So we gave the opportunity. Now they rejected the possibility. They consider that it was prejudged. It happened also in some court when the defender refused anything, and you cannot do it. So, but I think it's also one of our concerns, because to change this type of situation, what we need is the pressure not only of the public opinion internationally, which has a part to play, but it's also a change inside the different institutions about what is going on. And in this case, in a discussion, we can go further than just presenting the, between bracket, accusation. So I fully agree with you. It's not, but we are forced to work like that. And there were another one I missed.
On discrimination, the category that...
Discrimination. So my handwriting is so bad that I cannot read myself after. Yes, the discrimination, yes. The discrimination is not only on torture. I mean, the discrimination against Kurds continue to be something on the daily life of the Kurds community. Now, are there some other discrimination? Surely, but we have not here so clearly received, for instance, that women will be most systematically abused than men. There are cases of rape, but there are cases of rape on both sexes. You have cases also of sexual threats, and probably it's more often on women. And what we have mentioned also is the fact that to arrest the wife when the husband refused to collaborate with the interrogators is also some elements proving. And what we have, and that here It's a document which is not in the report. But what we have is that apparently the number of rape are much higher, particularly on women, since there are too much concern about what can happen to them if they denounce. And secondly, in some part of the country, they are ashamed about what it will mean for the family. But here we don't have enough systematic element to prove that this is a system. I would say it's more a patriarchal attitude in some family that can lead to that conclusion. But again, it's one source which underlines the fact that the women rapes are probably, against women are probably much higher than the one documented.
Thank you very much. Thank you. I think the session now is over.
The tribunal will resume its session at 12 o'clock. All rise.
Yes, of course.
Yeah? Okay. There are not many people. The tribunal, all rise.
So now we will start listening to the hearing of witness. Just a general comment. For the requirement and the guarantee of a fair trial, all the witness during the 3 days will be allocated the same period of time for their testimony, which is 20 minutes. I know it's short, but that's the constraint of the situation. So all the witnesses will be allocated the same period of time. So now for the session on torture, I will call first Mr. Mehmet. So you have testimony, and then we will have 10 minutes of question time.
Okay.
Thank you. You have the floor, sir.
Dear President, members, participants, hello to everyone. My name is Mehmet Alp. I was born in 1977 in Turkey. In Kütahya. I went to primary school and secondary school in Kütahya, and then I went to high school in Istanbul, and then to university I went to Bursa and I studied chemistry there. I did my master's in Cyprus. I did my doctorate in Turkey at the university in Gaziantep. And at the same time, I continued to work as a chemistry teacher for the Ministry of Education of the Turkish Republic. So it's about a year ago that my story begins. On the 18th of April 2015, I was in Cizre in southeastern Turkey. I was working as a teacher there, and I was forcibly abducted there. Later on, my wife was taken under custody. She was left free. She was released after 4 days. And then I was taken under custody in Urfa a while later, a month before the failed coup. Later, I was arrested, and I was put into Sincan, and I was said to be guilty of falsification and of swindling, but there was no proof against me. So I was in prison during the coup. And of course, on the 28th of May 2017, I was forcibly taken out of prison, and I was taken to the prison of Şanlıurfa, which is 600 kilometers away from Cizre. And for 24 days, I was tortured. I was once again arrested, and I was placed in prison. And on 4th of April 2020, I was released. And understanding that I couldn't do anything to prove my innocence in Turkey, I left Turkey and I sought refuge in Germany. So, unfortunately, there are many academicians, bureaucrats, innocent people in prison in Turkey, just like I was, and I accepted to come here today to be their voice. I would like to tell you about my experiments there. So, if I have to go into more detail, here's what I'd like to say. So I was a teacher in Cizre. Cizre is in the Kurdish region. It's a region where Kurdish people are in the majority. I'm from Kütahya. I'm Turkish. And my family was a conservative, nationalist family, a patriotic family, and so am I. But in Cizre, I experienced certain things. On 18th of April 2015, I took my child to a school for some school activities, and then I went into town. And while I was in town, a car stopped right next to me. I thought it was some friends of mine, so I stopped as well. And someone who came from behind me forcibly took me into the car. And then they took me outside of Cizre, towards Habur, towards the Syrian border. I suppose we drove for 30 or 40 minutes. On the road, they told me that they were policemen, but they didn't show me any proof of identity. They may have been policemen or MIT, the Turkish intelligence service. I don't know. They were very polite with me to start with. They said, you have 4 students. I don't want to give you their name, but I can give you one of their names. Medina Gökdemir, a female student of mine, was said to have joined the PKK. And they told me that these 4 students attended the Gülen movement's after-school classes, but that they also joined the PKK, and that Gülen and the PKK worked together, and that there was a huge terrorist organization. And they asked me to accept this. I said, I don't know anything about this. I've never heard of this, so I can't help you. And if this is an investigation, then we should go to the police station. And that's where I will accept to give you any information, but I have no information. And then, of course, they started to become less polite. They said, you're going to have problems, but if you accept this problem, then you won't have any problems. Soon in Turkey, there is going to be an explosion. If you don't want any problems, if you want to think about your family, if you want to take care of your children, then you have to do as we say. But when I didn't accept, this time they started to insult me. Right now, I have too much respect for you, so I wouldn't like to repeat what they said, which insults they used, but they were very heavy insults. So there was a policeman in front of me, behind me, another next to me, and the one who was next to me took a pistol against my head and said, if you want to continue living, then you have to accept what we're telling you. And I said, well, I don't know anything. How can I accept what I don't know? Of course, I was really afraid, and as I'm telling you right now, I'm afraid again. So I started to pray. I thought I was going to die. They said, if we kill you now, if tomorrow the police were to find your lifeless body, nobody could say anything because this is a terrorist area anyways. No one would do any research into your murder. So I started to cry. There was nothing else for me to do. They stopped putting pressure on me and they let me go. So they let me go there on the road and I started to hitchhike, but nobody stopped, of course. Finally, a truck stopped and I went back to Cizre. But once at Cizre, I didn't tell anyone. I didn't tell my family because I was afraid. So this happened on the 18th of April 2015. On the 20th of April 2015, the policemen came to my house. They took my wife under custody. She was taken to Ankara for 4 days. She was finally released. She came back to Cizre. And then the peace process between the PKK and the government had come to an end, and the armed conflicts began again. And we told the authorities that we were afraid for our lives. We told them that my wife could no longer leave the house to go and sign the papers that she needed to sign after she would be released from custody, but they didn't accept this. Finally, we were posted to the city of Şanlıurfa, and we were finally released from this problematic situation in Cizre. Once we arrived in Urfa, on the 13th of May 2016, policemen arrived at our home again. I would like to say this as well. I draw as well as being an academician, and so I drew everything that I lived through here. So while I was imprisoned, I kept a diary of 4 volumes, and I also drew pictures. And I put this in my files. And here you can see one of them. They're a nice memory. And so I brought them here so you can see them. 1 month before the coup in 2016, I was arrested, and they asked me whether I had anything to do with the Gülen movement. They asked if my wife had anything to do with them. They asked me why I sent my children to Gülen schools. But there was nothing to do for the reason for which I'd been imprisoned, which was, as I said, falsification and swindling. Well, I was arrested and I was put in prison. And then the coup happened on the 15th of June 2015. But I was in prison. On the 14th of July, we started to hear rumors that 2,500 prosecutors and judges would be imprisoned and brought to our jail. I asked, but how? How could 2,500 judges and prosecutors be imprisoned? We heard these rumors on the 14th of July, and then on the 15th of July, we heard about this coup. And that night, we had only 11 people in our cell. We went up to 20 people, if I remember correctly. There were academicians and bureaucrats and teachers in our cells. In the other cells, there were CEOs, high-level bureaucrats. And 2 days after the coup, we were taken from Sincan L-type prison to T-type prison. But we weren't allowed to take anything, not our clothes, not our books, nothing. Not any cutlery, nothing. We were taken to a cell, an empty cell, without beds, without covers, nothing. For 2 months, we weren't able to eat any vegetables or fruit. We weren't able to see a doctor. We wrote complaints, But we couldn't get any answers, so none of us could see a doctor. Later on, we learned that around 2,500 prosecutors and judges had been imprisoned and put into where we had been before, Xinjiang T-type jail. Well, of course, after all the stress, I started having digestive problems in my intestines, and I started having internal bleeding. And despite the fact that while in jail, I asked to see a doctor, despite the fact that I pushed the red emergency button, no one came. Finally, someone came. I said, I'm in pain. I'm bleeding. I can't eat. I'm in a very bad situation. I really need a doctor. And I was told that I was a member of the FETÖ terrorist group, that I was a Gülenist, and that they'd received orders not to take care of me. I said, well, then give me a document saying that you're not taking care of me, that you're not taking medical care of me, because I'm in real trouble here. Now, this could be worse. But for 2 months, they didn't take care of us. Later on, I was taken to a hospital after 2 months. And I was told that I had a beginning of intestinal cancer. And of course, I had to take a lot of medication. Later, in November, I was taken from Xinjiang to Keskin Te, another jail, and I was given no reason for why I was being transferred. I think I've been through 4 jails and 17 cells. And I was put in solitary in this new jail. And while I was there, on the 28th of May, 2017, a police officer came and said, okay, you have to get out of solitary because you're going to appear before court, so come out. And I said, no, there's still a week to go before I appear before court. And they said, no, you have to come out. And I said, no, I don't want to come out. Because I was thinking of bad things, because after the 15th of July, there were many people who were tortured. But then I was like, this is a state where still there's rule of law. It's not easy to torture someone. That's what was going through my mind. But they forcibly took me out of my cell. And then they took me out of the prison. And 2 people came and handcuffed me and put me on the ground and took me 200 kilometers away to Şanlıurfa. On the 28th of May, they asked me whether I had fulfilled any functions during the coup of the 15th of July. Well, no, I said. On the 15th of July, I was in jail. I'm a student. I'm not a member of the military. I can't be meddled in anything like this. They said, no, we know that you were involved. We're going to give you some documents which you're going to sign. I said, I don't know what these documents are. Give me these documents. Let me read them first. They refused to give me the documents, so I don't know what they were about. And that night, since I refused to sign these documents, that evening, they put a sack over my head. They handcuffed me with plastic behind my back, and they took me to a dark room underneath the prison. And they said, okay, the police officers left me alone. They said, okay, we're leaving you with these people, and they're going to ask you some questions. So they turned me against the wall. They put me on the floor. I suppose there were a few people in the room. I had a sack over my head. I don't know how many people there were. And they had metallic things in their hand. And they said, we know that you're involved with the 15th of July coup. You won't get out of here alive if you don't help us. But once I told them that I wasn't involved, they started to hit me over the head, over the body. I fell. I'm trying to get back up. I said, no, there's a misunderstanding. I'm a teacher. I'm not involved in any of this. Finally, I remember I started bleeding from my nose, and then I fainted. Then I was placed in a van, and they took me to the hospital of Şanlıurfa. A doctor arrived while I was in the van, and they looked at me from outside. He looked at me from outside, and he asked me what was wrong with me. But while we were on the way, the policeman told me that if I told anyone that I'd been tortured, they would bring me back and they'd torture me again. So, as I told you, I'm a cancer patient. I also have high tension. I started having arrhythmia. I'm under 4 drugs. So I was afraid. So they took me back, and for 24 days I was tortured. I met many academicians who were tortured. I thought, I'm never going to make it out of here alive. What should I do? So during questioning, let me show you. So when I was placed in the room of Tim, I found a pencil, and I broke it, and then I found some toilet paper, and I put the pencil at the edge of this paper, and I made a pencil out of it for myself, and I made some paper as well, like this, and I started to write down everything that I've been living through every day, because I thought I would never make it out alive. And I kept all this. I put these little notebooks in my shoe. I wanted to see my lawyer. I asked to see my lawyer, but they wouldn't allow me. I said I wanted to see my wife. I wanted to tell my wife I'm under custody, but they didn't allow me to. And then on the 6th of June, I was supposed to appear before court. So from 28th of May till July, I was placed under torture every day. Finally, I was able to go to court. So the policeman who tortured me told me, if in court you tell anyone you were tortured, then you'll undergo the same things. But I was afraid for my family. They said, we won't only torture you, we'll torture also your wife and your family, and your children will go to adoption homes. So if you say that you love your family, then don't tell the court that you were tortured. So they gave an envelope to the judge, and they told him to release me. They said that I would be released afterwards. And there they say that they have a euphemism for torture. They call it an operation, as a medical operation. They say if you do anything wrong, we'll operate on you again. So the day I was released, actually, conditionally, they also told me that I was guilty of being involved in the 15th of July coup. But then I was imprisoned again. I was arrested again. Again, I had to appear before court. Again, the policemen who tortured me were in court, and they made me sign a document saying that it was my own responsibility that I hadn't taken my medication. But I changed my signature. And I met with an academician who had been tortured with electricity. He had ecchymosis everywhere. One of his ears he was deaf in one of his ears. He said, I have to get out of here alive, I said. I have to get out of here alive to continue my fight for everyone, for freedom and justice. And I said, I want my own lawyer. They said, no, you can't have your own lawyer. If you don't sign these documents that we ask you to sign, then you won't leave here alive. I said, but you're a lawyer. You have to defend me. How can you say anything like this? But unfortunately, no one supported me. And together with this lawyer that had been assigned to me by the state, well, I was still tortured. Finally, I was able to see my own lawyer. My wife had learned that I was in this prison in Urfa, and my wife came together with my own lawyer, and once she entered, I thought that they'd brought my wife to threaten her. I thought that they were going to threaten her with torture, with imprisonment, with rape. So I asked my wife not to come very often. I said, maybe you should. I asked my wife, together with her own lawyer, to go and see some human rights organizations. And so she went to the Turkish Parliament's Committee on Human Rights. She went to speak with some politicians. She went to the bar of Urfa. She went to some other political parties and some journalists and told them about what I was going through. But on the 4th of April, I was again released conditionally. But I understood that my problems were never going to end. So together with my wife and children, we escaped the country and sought refuge in Germany. And that's where we're continuing our struggle. Thank you.
Testimony. Now I will turn to the judges for a question time, and maybe we'll start with Justice Pace, if we can have him on video. OK. Voilà.
Mr. Alpert, thank you very much for coming to us. Did you